Okay, I want to tell you about a situation that on the surface looked like a family dispute. But what it actually was the Alberta Intestacy formula doing exactly what it was designed to do. The problem was, nobody in the family had ever read the formula designed to dictate what happens when you don't have a will. You see, in this case, there was a person who died without a will. He had been married for many years, but his wife had an advanced illness and had been in long-term care for some time. He also, in this particular case, had a girlfriend who lived with him in his home. And she was there long enough to qualify as what Alberta calls an adult interdependent partner, a common law spouse. And he had a third woman in his life, a girlfriend whom he supported financially. 3 women, no will, no agreements of any kind. The children of the marriage, children of his wife, who was still very much alive but unable to advocate for herself, they didn't want this live-in girlfriend to receive anything from their father's estate. They felt strongly about it, and they said so clearly. It didn't matter what they wanted, because the live-in girlfriend qualified under the Act. Under Alberta law, she was entitled to claim a share of the spousal amount from the estate. Half of it to be shared with the legal spouse. She made the claim, and she received it. The third woman, the external girlfriend, actually also made a maintenance claim of her own on the basis that she had been financially dependent on him. And in the end of the day, this was settled out of court. A will, an adult interdependent partnership agreement, a prenup marriage contract, any of these kind of documents could have changed the outcome of this file entirely, but this individual had none. All right, I'm Chad Graham. I am a lawyer, a state lawyer in Edmonton, Alberta. This video provides general educational information and not specific legal advice. Let me tell you what dying intestate means. It means dying without a valid will. And when that happens in Alberta, the province steps in with a formula set out in Part 3 of the Wills and Succession Act. And this determines who gets what. Now, the formula doesn't know your family, it doesn't know your relationships, it doesn't know what you would have wanted. It applies the same rules to everyone because that's the only rules it has. And most Albertans have never read this formula. Most Albertans assume, for example, that their spouse will get everything, that their kids will be well taken care of, and that anyone outside the immediate family gets nothing. On all 3 of those assumptions, the formula can surprise you. Here's the basic structure, as simply as I can state it, oversimplifying to be fair. When someone dies without a will in Alberta, they die intestate. And if they have both the surviving spouse and an adult interdependent partner and descendants, the spouse or the AIP receives what's called a preferential share off the top, a dollar amount set by regulation, plus a portion of what remains, and the descendants then share in the rest. So many people just believe, well, my spouse will automatically get everything if I die without a will. And if you die with a spouse or an AIP spouse, and you have no descendants, or your descendants are through that spouse, then the answer is probably yes. Your spouse or AIP will generally receive the entire estate. But many Albertans don't have this simplified life. They might have a surviving partner and children from a previous relationship. They could have been widowed, they could have been divorced. In that kind of case, the formula applies. The preferential share first, and then a split of the remainder between the spouse and the children. And in the story I opened with, there wasn't just one partner, there were 2, a legal spouse and an adult interdependent partner. And this changes the calculation in ways the family had never even considered. So just 1 second, we need to go back into what an adult interdependent partner is. Under Alberta's Adult Interdependent Relationships Act, a person qualifies as an AIP if they have lived with you in a relationship of interdependence. Now, this isn't quite black and white, but there are some markers for this. If you've been living together consecutively for 3 years, or a shorter period if you've had a child, you almost certainly qualify, and there are a few more things around that. Assuming that you're in there, you don't need to have used the term AIP or even know what it is. You don't need to use the term common law, although that is often used here. If the relationship, the timeline, the criteria are met, the status is achieved by operation of law. Now, in the file I described, the living girlfriend had been there long enough to qualify. And she'd not signed an AIP agreement. He'd not signed one, of course, either. Neither of them maybe even knew the term existed, but when he passed, She had legal status, and with it the right to claim a share of the spousal amount of the estate. The children of the marriage were understandably upset. They were watching their mother's estate, their father's estate, their family's estate go to someone they didn't recognize as family. But the law recognized her, and the law doesn't ask children for their opinion. Now, when you look at standing for how this is going to work, there are a little bit of complications here. That third person in that initial story had ambiguous standing. She wasn't living with him, and she didn't qualify as an adult interdependent partner. He already had one, but she had been financially dependent on him. He had been supporting her, and through that, it gave her a basis for a Part 5 claim under the Wills and Succession Act. Whether it would have succeeded is an interesting question, but the family settled that off out of court. The claim existed, it had some legs to it, and resolving it cost the estate money and the family considerable stress. Part 5 claims, by the way, are not limited to intestacy. You can have a will perfectly laid out, leaving everything to your wife, but if you've now got an AIP, they can have a claim. Or if you have a child who is dependent but who is not provided for, they might have a claim. There's all kinds of ways in which this can come out. So when I hear people say, hey, if I don't put her in the will, she gets nothing, that's not quite right. A will is indeed a powerful tool, but it operates within a legal framework that includes rights for certain people regardless of what the will says or doesn't say. So if you have a relationship that creates legal obligations, just having a will may not sever them. That's why talking with your lawyer matters. There are ways to frame it and other agreements that might need to be done around it, such as an adult interdependent partnership agreement, a prenuptial agreement, an agreement within the will, or other arrangement with another person. This would have changed the outcome in the file I started with, and it might really change the outcome in your family's life as well. The law does not simply leave a gap when someone dies without a will. It fills that gap with a formula written for the average case, not your case. And as the story I told you shows, the average case can look nothing like the way a person actually lives. I've sat with families who were blindsided by these intestacy rules. Not because the rules were hidden from them, but because they'd never been told the rules applied to them. They assumed love was enough. They assumed the relationship was obvious. They assumed their children would just sort it out. Love is not a legal instrument, but a will is. So is an adult interdependent partnership agreement or prenuptial agreement. These documents exist precisely because the relationships in our life are complicated, and the law needs something to work with. So if you have people in your life, complicated relationships, or even simple ones, there is a conversation worth having before the formula gets decided for you. Look me up, chadgrahamlaw.com, and I'll see you in the next episode.